recording now, so.
All right. Hello, my name is Kristina Crump. I'm a practicing attorney. I practice bankruptcy law here in Kansas. This is my partner, Chris Coons.
Hi, I'm Chris Coons, and I think for probably the past 20 plus years, I have been a consumer bankruptcy attorney, and it's been kind of the focus of my career and Kristina's career. We have a law firm, Coons and Crump, and we only represent debtors. We don't do any creditor work.
We also don't do any Chapter 11 work, or Chapter 12 work. Basically, Chapter 7s, Chapter 13s.
Chapter 7s, Chapter 13s, yeah, that's probably better than just saying consumer work. We occasionally will do a very, very, very small business case, or we'll do a non-consumer case. But for the most part, we strictly stick to consumer debtor work.
Yeah. Well, today we're going to talk about divorces, or intersection of bankruptcy and divorce. Least favorite subject here, mostly because I hate those phone calls that come in, oh, I'm about to get a divorce. What do I do? Well, for once, it creates a conflict of interest, potentially a conflict of interest for us when we answer those phone calls when our clients are contemplating a divorce. What's your position on that? I know we vary. I want to get out right away.
I am massively too soft. I read the rules of ethics as saying there are times when you may get out and times when you shall get out. And there are cases in bankruptcy where I will try to stay in and shepherd the clients to the end of the case as long as I feel they can waive the conflict. I typically want both of them to have counsel. It is not uncommon for me to wake up in the middle of the night in a cold sweat because I'm upset that I did not withdraw from the case. But I'm probably a little bit more permissive. And you, on the other hand?
Well, my first instinct is always to try to get out because I just think the options, that people have individually versus as a couple are quite different, and a lot of times it is difficult to advise your clients without mentioning those options. But forget about all of that. What if you're a divorce attorney and your client is in the middle of a bankruptcy, or you just find out that your client is in the middle of the bankruptcy? What do you do?
Yeah, well, this happens. I mean, we get these calls, and where our clients have filed for divorce and nobody has told us, and then I'm getting a call from the divorce counsel, and they have a hearing set a month or two away, and they want to know what needs to be done. And the problem there is almost always I do have to get out, usually at that point, because I don't know about it. On occasion, I can stay in, but in order for the divorce case to proceed on division of property and debts, which is one of the fundamental aspects of a domestic case, you have to have relief from the bankruptcy stay. So I try to explain to everybody.
What is the automatic stay?
Okay.
Explain the automatic stay to all the divorce attorneys and how much it matters and that they really should be paying attention to that.
Okay, so if you represent normal people, normal citizens that are walking around, the automatic stay is the largest legal club that they have at their disposal in civil practice. So the automatic stay is the injunction that is created when a bankruptcy case gets filed, and the injunction gets sent out to all of the creditors in the case. Now, the debtor is supposed to list all of their creditors. Sometimes they don't, whether it's by accident. Sometimes they think they don't have to, but they're supposed to. But that injunction tells everybody you've got to stop attempting to collect on your debt. You've got to stop any proceedings. Judicial proceedings are stopped. Administrative proceedings are stopped. And you should think of the automatic stay as applying to just about everything. And then there are exceptions within the automatic stay that tell you what you can proceed on. Like child support is, the establishment of child support, the establishment of paternity, the dissolution of the marriage if you're not dividing property and debts, these things are generally not stopped. But the automatic stay is essentially this gigantic club that hits everybody in the head.
But it's not just about dividing debts. It's also about potentially dividing property. Do you need relief from the automatic stay to divide that?
I think the answer to that is always yes, although there may be some property that is not property of the bankruptcy estate, but is property of the marital estate. And
Sometimes.
yeah, right, yeah. And so you might not need relief from the automatic stay to divide up a ERISA qualified retirement account, like a ERISA qualified 401k, because there is language that excludes that from the property of the bankruptcy estate. And there's case law in Kansas that mentions this. One of our judges actually has a recent case that actually goes through that analysis and says, well, it's not really property of the estate. But for all other property, I would argue that you need relief from the stay. Now, there are other arguments that say, well, if this property was exempted in the bankruptcy case, then it's exempted from the bankruptcy estate, and arguably you don't need relief.
So what happens if you don't get the relief from automatic stay?
I think that any orders that were prohibited by this, or any property and debts that were divided up in orders out of the divorce case that were in violation of the automatic stay are automatically void. And the same case I was talking about earlier makes that clear, that when you get these orders and they violate the stay, they're just void.
Yeah. So best practice, I guess, would be to get relief from the automatic stay or file a motion.
Yeah, I mean, I am always amazed when people do not file motions for relief. A great example is, somebody will come to me later on and say, well, I got divorced while I was in my bankruptcy case, and we never got relief, and I got the house from my spouse, but now there's a cloud on the title because there was never any relief granted in the bankruptcy case, and a title company is going to look at that and basically say, well, you didn't have relief from the bankruptcy court, and so that transfer was ineffective. Are they correct? Probably. I'm not going to say 100% that I think they're correct, because the house may have been exempted, and there may be an argument that because it was exempted from the bankruptcy estate, nobody objected to the exemption, maybe you don't need relief. But I would get relief no matter what. I would always get relief, even if it's just a comfort order. I would get relief, because the title company it's not bound by what we think is correct.
Correct.
I'm not their legal.
They like comfort orders.
They like comfort orders, and I'm not their legal counsel.
And our judges sign comfort orders all the time. Bankruptcy judges, that is.
Our bankruptcy judges understand that there's a need for those orders, yes.
Yeah. I think one of the other things divorce attorneys worry about is the concept of dischargeability. What debts are dischargeable, debts out of divorce, that is, be it alimony, child support, maybe property division.
Right.
What can a bankruptcy discharge, and is there a difference between Chapter 13 and Chapter 7?
Yeah, so here are the safest words your client can ever tell you if you're a domestic attorney, and it's, let's say it's 6 months after the divorce, and the client shows up and says, my ex filed a Chapter 7 bankruptcy, and immediately you can go back to sleep. You can go, don't worry about it, no big deal, because the Chapter 7 bankruptcy is not going to discharge basically any obligation to your client out of that divorce case. Can it discharge the obligation of the ex-spouse to the credit cards? Sure. But if the divorce decree says that they're supposed to pay that debt and they filed a Chapter 7, your client can go back into the domestic case and essentially get an order of contribution to be made whole on that debt. So Chapter 7 is arguably not fundamentally dangerous to your client. There is an automatic stay, though, and at least during the stay, it's going to prevent collection on those matters. Okay, but a Chapter 13, I think, is where we start getting into the weeds. You not agree with that?
I do agree with that. What are some of the, I guess, dangers of having your client's ex-spouse file a Chapter 13?
Well, first off, in Chapter 13, we're going to break those debts that come out of a divorce decree into two categories. We're going to have one category that we're going to call domestic support obligations. And typically when we think of a domestic support obligation, we're thinking of child support, alimony, spousal support, whatever.
I'm just going to interrupt you for a minute.
Sure.
Is there a definition of domestic support obligation in the bankruptcy code?
Yeah. I mean, it is an obligation for the support of a party, but I mean, I'd have to go back and take a look. Courts have, I really want to be careful because yes, there are definitions for this, but here's the thing you have to understand. The court looks beyond the definitions when it's looking at what was done in the divorce case. So the court looks at the intent of the parties.
So would it be safe to say like child support is always domestic support obligation?
Yeah, I think so. I've never seen a case where it's not. And I think if you look at the establishment of something like child support, that is something that's going to be outside the scope of the bankruptcy court.
What about alimony?
Okay, so I think that generally an alimony award is going to be outside of the scope of the bankruptcy court. It's going to be outside of the scope of being discharged. It will be a domestic support obligation. But could I imagine a case where somebody said, you owe me 15 grand. I'm going to call it, spousal maintenance. And you're just going to pay me back. And then when the court takes a look at it, the court goes, well, this really isn't spousal maintenance. And could I see a court finding a fact pattern where they look beyond the terms that are used in the state court? Yes. Now, I would point out that there's probably a big difference between what a trial court does at the state court level and how the bankruptcy court views a trial court decision versus how they view a property settlement agreement. So, property settlement agreement didn't go to trial. A judge didn't write that up. Essentially, the parties wrote that up. It's a contract between the parties. And so the bankruptcy court is going to give, I believe, a lot more weight to the decisions of a trial court. They're not going to go back and really rewrite things if the trial court has made it clear that this is a alimony or spousal maintenance award, spousal support award. They're not going to go back and rewrite that. I think that's going to stand. And in a Chapter 13, those domestic support obligations are going to be non-dischargeable. But things that are not domestic support obligations are arguably going to be dischargeable. So you do run into some issues where, I don't know, we've had the house issues where somebody has an equitable lien because they were awarded $40,000 out of the home and the opposing party ends up filing a bankruptcy and saying, well, I don't owe you the 40 grand. I don't owe you the 40 grand because I filed bankruptcy and that was a debt I owed you. Yeah, it's a debt, but quote, the debt obligation might be dischargeable, but the equitable lien that you have on the property, which in theory would allow you to go back into the divorce and force a sale on the property, that's probably not going to go away. Once again, though, that might be a litigated issue in the bankruptcy court.
Sure. I don't know what else to ask. What else am I going to ask you?
Well, what about
can you include any kind of language in your divorce agreement? Can you craft an agreement in such a way that it will be basically, or your client would be basically bulletproof in
No.
bankruptcy. Can you waive somebody else's
Now, you
bankruptcy rights?
can't contractually waive bankruptcy rights, and
Yeah.
any attempt to do so is probably just completely void. So, and that applies outside of the context of domestic cases. Just in general, you can't waive that right. But you know, it comes to us all the time. The hold harmless agreements, and this is in the nature of
those
support.
special clauses.
Absolutely,
Yes.
and I don't think those are worth very much.
Yeah, we ignore it most of the
Well,
time.
we tell our clients they're not effective.
Oh, correct.
Yeah, we tell our clients they're not effective, and we don't get challenged on them very often.
No, not very often.
Yeah, no, we do get disguised domestic cases though. Have you had any disguised domestic cases? Don't tell war stories.
No, I have horror stories about that for sure.
Which do you want done first, the divorce or the bankruptcy? As the bankruptcy
As a bankruptcy attorney, I absolutely want to get the divorce done first, most times.
Right. And what do you think the divorce attorneys want?
I'm sure they want the bankruptcy
done
done
first.
first. And sometimes that makes sense.
Yeah, it does, actually.
I mean, one of the things I think to remember about this is you really need to understand your client's financial situation, whether they mathematically might not be able to pay their bills after the divorce because it is two incomes, or a family had two incomes and now there's one. So sometimes it's just easy to see that it's inevitable that somebody will file a bankruptcy. Do you, I mean, as a bankruptcy practitioner, do you know when people absolutely must file or have to file, or thinks it's just going to be a disaster if they don't?
Well, I know, but I'm not sure. I'm not sure anybody else knows. I mean, I can look at I often refer to it as the triumph of hope over mathematics. I think you've heard me say that before.
Sure.
And people just suffer from this idea that they're going to escape the math of their situation.
Well, it's kind of like if your client makes $20 an hour and now has to have separate apartment to live in, and they have a car payment, they cannot pay $20,000 worth of debt outside of that. So in that regard, you know, not addressing the debt issue, I guess, is kind of inviting.
Do you think divorce
bankruptcy in a way?
Well, do you think
Yeah.
divorce is one of the big factors that we see in our office?
Oh, absolutely.
Yeah.
Oh, absolutely. A lot of people file bankruptcy because they got a divorce and now they
divorce.
lost that other income.
Well, I see it all the time. Yeah,
Sure.
I mean, like, I see it several times a month at a minimum.
Oh,
you
sure.
know, at an absolute minimum. So,
Yeah.
well, I think we've got more to cover, but I think we're going to stop for the moment, and we'll come back and cover some other issues. If you need to stop creditor calls, harassment, collections, lawsuits, repossessions, garnishments, or foreclosures, please give us a call. Consultations are free.